Welcome to Telugu One Academy. In today's class, we discuss about National Commission for Minorities. We have a statutory body. We have discussed a few constitutional bodies, 5 statutory bodies. National Commission for Minorities is a statutory body. As we all know, India is a secular country, and we have a good number of population belonging to different religions. Other than the Hindus, we have population from other religions like Muslims, Christians, Sikh. We have population of Buddhism, Buddhist, Jains and Zoroastrians as well. So to protect the rights of minorities, both religious minorities and linguistic minorities, minorities on the basis of ethnic, that is nationalism, ethnicism, religion, language, etc. We have this commission. We have a statutory commission, National Commission for Minorities, which is established for the protection of the rights of minorities. So in this class, we would be discussing what is the need of such a commission in India, how this National Commission has actually established, then the composition of such commission, the functions of the commission, and the important parameters on which the commission functions. So National Commission for Minorities. Initially, the National Commission for Minorities was not established as a full-fledged commission for minorities. So we had a commission, that is, we have a minority commission. It was just a minority commission which was created in 1978. So in 1978, we have a minority commission which was a part of Ministry of Home Affairs, that is at central government level. The Minorities Commission was created in this ministry. So Ministry of Home Affairs had the Minorities Commission in that. It was not a full-fledged commission. It was not a national commission for minorities, and it was not a statutory body as well. So initially, just to protect, because as we know, Ministry of Home Affairs is mandated to protect law and order in the country. It will also take up the issues related to states in the country. So Minorities Commission was initially set up in the Ministry of Home Affairs by an executive resolution. Then in 1984, the Minority Commission was detached, that is, was taken away from the Home Ministry, the Union Home Ministry. The Minority Commission was taken away, and it was newly created. We have a newly created Ministry of Welfare. Ministry of Welfare was there. We have taken away the Minority Commission from Home Affairs and we have attached to Ministry of Welfare, because there was a need felt that Minority Commission specially envisages on the safeguarding the rights of the minorities. Here, safeguarding the right is not only just protection of the constitutional rights, but also to promote and to make such actions which caters to the development of the minorities. That is, for the both welfare activities and development activities, certain steps need to be taken by the government in order to have a equitable development of religious and linguistic minorities at par with other sections of the people. So as we know, we have a secular polity, and the state government or the government, the central government or the nation does not follow any particular religion. So it is mentioned in our fundamental rights also that the state has to give equal importance to all sections of the people, all religions. So Article 15 says that there have to be no discrimination on the basis of religion, region, caste, sex and other things. So this mandated that the central government need to give a impetus to such minorities, and it has added this minority commission in Ministry of Welfare. So when we say welfare ministry, it obviously works for providing basic amenities to the needy people, to the people who are below poverty line, or to the people who are not getting the fruits of development. So Ministry of Welfare was created, and the Minority Commission was set up in Ministry of Welfare. And as we know, the National Commission for Minorities, this is in 1992. In 1992, we have established a National Commission for Minorities, which is created by a statutory, that is by a resolution of the Parliament, and hence we call this as a statutory body. So the National Commission for Minorities Act created the National Commission for Minorities, and which has then the Minority Commission was renamed as National Commission for Minorities. In 1992, a full-fledged a separate National Commission for Minorities was established. Now it's not part of any ministry or any ministry. Initially, the Minority Commission was a part of Ministry of Home Affairs. Then a new ministry was created, that is Ministry of Welfare, and Minority Commission was added to Ministry of Welfare. Then we have enacted a separate commission, that is National Commission for Minorities, and which is an autonomous body. Though it's a statutory body, it has a sense of independency. It will recommend the government on various aspects related to the socio-economic conditions of minorities. Again, when I say minorities, at present we have 6 religious minorities. Before 2014, we have actually only 5 religious minorities, that is Muslims, Christians, Sikh, we have Buddhist, we have Zoroastrians. After 2014, Jains were added to the list of religious minorities. At present, we have 6 religious minorities. So in 1993, the first statutory commission was created. So it has came into function in 1993. So initially we had 5 religious groups, and among them Muslims were important, because they have now at present they have more than 14% of the population. So Muslims, then we have Christians who are almost around 2.7% of the population, then Sikh community, Buddhist, Zoroastrians and Jains, they are no less than 1% of the population. So here when we say minorities, the Muslim community becomes important. The majority of the population in this minority religions groups are Muslims, followed by Christians. So both Muslims and Christians combined, we have 90% of the minority population. So to have a comprehensive growth, to have a equitable development, to protect the secular fabric of the nation, the minorities has to be given an equal importance. That is, when we realize the importance, the necessity of brotherhood, the necessity of equality, then only we could secure the the concepts which is mentioned in the preamble, right from the brotherhood, socialism, secularism, equality, justice, fraternity and all. It is only possible when we give due importance to every section of the society, and no person is left out of the development process which is taken up by the government. So we have 6 important religious groups. Recently in 2014, Jains have been added to the religious minorities. So there are many issues taken up by the commission, the Minorities Commission, and the commission on minorities, that is National Commission and Minorities, will take many issues right from developmental issues, right from welfare issues, issues related to protection and safeguarding of their fundamental rights, issues related to women, issues related to education, protection of their culture, their progress, on various matters which is related to these religious groups. So, it is a comprehensive commission which gives recommendations to the government on various matters. So, I will try to understand that when we discuss about the functions of the commission. So, what is the composition of the National Commission for Minorities? So, we have in total 7 member body. We have 7 members, that is 1 chairperson, 1 vice chairperson and 5 members. This may be probable question in the examination. 1 chairperson, vice chairperson and 5 members. All these members have to represent, have to be from the from those minority groups only. So, from those minority groups, depending upon the proportion of their population, the National Commission for Minorities will be composed of these peoples from the minority communities only, because no, the commission works for the welfare of the minorities, the commission works for the development of the minorities, and this commission is mandated to give recommendations to the government on various aspects, through which the government can bring policies and programs for the upliftment and for the progress of the minorities. And this is the composition of the National Commission for Minorities. So, in total we have 7 person, 1 chairperson, vice chairperson and 5 members nominated by the central government. As we say, the members should have should have knowledge, should have understanding, though they are from those minority communities, still they have to have the special knowledge and understanding about such religious groups. So, they have to be eminence and ability to understand the conditions, the living conditions, or what need to be what actions need to be taken for the growth and development of such religious minorities. So, the tenure of these members, the tenure of members of National Commission for Minorities is 3 years. 3 years is the tenure of the National Commission for the Minorities. This may be the probable question. There may be a question like, what is the tenure of members of the National Commission for Minorities? It is 3 years. So, this is important. Functions of National Commission for Minorities. So, as we know, since years, the minority groups, that is religious minorities or linguistic minorities, been facing many problems. The problems they are facing is exclusion problem, that is, they are not made participation in the governance of the nation, be it right from giving them the educational benefits or health benefits, or providing them with shelter, giving them the opportunity to participate in the government or the opportunity to participate at political level. So, all these things, many of the things may be not reaching to such person, though we know that there is a system of reservation, but most of the reservations are given to SCs and ST and backward classes, that is OBCs. But when it comes to religious minorities, obviously they are not considered as SC, STs and OBCs. So, in that process, most of the minority communities, religious minorities communities, being also very backwards, that is, the minorities, though they are from below poverty line, many of them are not in the ambit of the government's programs. So, the programs or the policies of the government, be it welfare policies or developmental policies, these policies are not reaching to such people belonging to the religious minorities. So, to ensure that the programs of the government, whatever the programs of the government, welfare program or developmental program, in order to reach such programs to these needy people, poor people in minority religions. We have brought in many policies so that these programs reach the people belonging to the minorities also. So the important function of National Commission for Minorities is to evaluate the progress of the development of the minorities, because minorities are left outside the ambit of the development. Generally we see even in Muslims also we've seen a lot of poverty, because there is a continuous exclusion process, or we may say that the reservation is not applicable to such community, and because of many other matters, many other issues, the Muslim community or the Christian community have been left outside of the ambit of development. I'm not saying that it is like wantedly done, but by many other reasons the government could not take steps, because here there may not be a body which exclusively works for the development of such minorities, and that is the reason we have created an exclusive commission which recommends the government, both state governments and central government, on various aspects, various matters related for the growth and development of these religious minorities. So important function is the evaluation of progress and development of minorities. So minorities of both union and at union level and at state level, and monitoring of the working of the safeguards for minorities. See, we have in our constitution, we have many fundamental rights, like we have Article 15. Article 15 like it prohibits the discrimination on the basis of religion. We have Article 16 which provides equality in employment. We have Article 29-30, the educational and cultural rights given to the minorities. We also have religious freedom, that is Article 25, Article 26, Article 28, which empowers anyone, any person or any individual to profess, to propagate their own religion, to manage their religious affairs. So all these fundamental rights guaranteed by the constitution have to be implemented. That is, the state governments should not bring any policy which takes away the rights of the citizen, especially minorities. So here the National Commission for Minorities functions to monitor and to safeguard the fundamental rights of these religious minorities. As we know, Constitution guarantees such rights, but few actions of the government may take away the rights of the minority groups, and in that case the Supreme Court or the High Court will come to the rescue of such aggrieved people. And this is an important aspect in the history of India, when we say that there is a National Commission for Minorities, and there have to be some programs or policies drafted by the government which is targeted to develop the minorities, to develop the religious minorities. So generally there is a lot of poverty, lot of malnourishment, lot of educational problems, lot of unemployment in minority groups also. So generally we have seen that the livelihood conditions of minorities are more worst than SCs and STs in many parts of the country. So in order to give an inclusive development, inclusive growth, in 2004 we have brought this 15-point program. Actually in 2004 there was a committee, Sachar committee. Sachar committee was established to give recommendations on the various aspects or various problems facing by the minorities. It was in 2000 on the basis of such recommendations of Sachar committee, the 15-point program for the welfare of the minorities was implemented under the Congress government, or we can say that UPA government, when Manmohan Singh was the Prime Minister of India. So 15-point program So this 15-point program are exclusively for the growth and development of the minorities of all religions. So important such programs like providing basic infrastructure to the minority people, like providing them with Awas Yojana, giving educational benefits like implementation of Sarva Shiksha Abhiyan in in the pockets where the minorities are located. So giving them the Sarva Shiksha Abhiyan, providing free education, midday meal scheme, distribution of uniforms, books, and those basic necessities needed for the enrollment in schools and completion of their primary and secondary educations. And we also have in this 15-point program, we have program like employment guarantee schemes. We have program like youth employment. The government will provide with some some policies to minimize the unemployment in minorities. So we have other programs like giving loans for self employment. And there are many such things of providing basic amenities, right from education to health to development. So these 15-point programs are targeted towards the growth and development of the minorities. So the National Commission for Minorities will ensure that all these 15-point programs are implemented by the government at union and state level, and also at grassroots level, so which could bring the growth in the lives of the minorities. So implementation of such programs have become an important function of National Commission for the Minorities. Actually, there was a lot of criticism also on such programs, because many states have opposed an exclusive program which is targeted only for the growth and development of the minorities. What they call it as an anti-constitutional, because constitution doesn't provide such provisions that giving reservation or providing few programs targeted towards the growth of only single section of single community. But actually what happens is we are providing the programs at India level, at national level, but the special target is given. And there was also a provision of providing around 15% of the budget allocated for the growth and development of the religious minorities. Even this step of the government was opposed by many states. Nevertheless, the program was implemented, and we have achieved good progress in terms of education, in terms of health, in terms of improving employment. So the 15-point program was an important step taken by the government in order to improve the lives of minorities. And other things is making a recommendation. The National Commission for Minorities, having 7 members specialized in various various parts of the things. They are experts, maybe experts in education. They might be professors. So they are experts on religious matters. So they have recommended on various matters, which has to be generally the recommendations are though not binding, but the government will accept such recommendations. These recommendations may be helpful when the government is preparing any policy, or the government plans for the development and growth of the minorities. So these recommendations, in the interest of protecting the rights and safeguarding their rights of the minorities, these recommendations are accepted by the government, and it is the function of the National Commission for Minorities. And we also know that these commissions, as we have many other commissions, we have commissions for SC, commission for ST, we have National Human Rights Commission, we have Commission for Women's. As all these commissions, this National Commission for Minority will also act as a quasi-judicial body. It will look into the complaints because there are a lot of atrocities generally the minorities will face, because we know majority of the population is Hinduism. More than 80% of the population, around 80% of the population of India practices Hinduism. And generally what happens is that in some states where the Muslim population or Christian population or in small numbers, obviously there may be a lot of atrocities facing by such minority people. So in order to ensure the law and order, in order to protect their fundamental rights, their natural rights, their human rights, the National Commission for Minorities would generally receive such complaints and act on such complaints. So looking into the specific complaints regarding the deprivation of their fundamental rights and to safeguard such rights, and to also give recommendations on various steps need to be taken by the central government or by the state government in order to protect the life and liberty of the minorities. So it would look into complaints. So suo motu also the National Commission for Minorities could take certain steps in order to safeguard their rights, but they also look into the matters when any aggrieved person, any person who have faced the problem will come to the commission and register the complaint. So we have seen there were many communal rights also. So on such matters also the National Commission would take the action. So we have seen there are many sensitive places in the country, like we have seen riots in Gujarat, riots in Hyderabad or various parts of the country, especially when it comes to some communal religious practices, there will be disturbances. So on such matters also National Commission for Minorities would look into in such matters. So we have Minority Rights Day. Minority Rights Day is generally observed on 18th December. 18th December every year we observe Minorities Rights Day, because on this particular day, on 18th December, United Nations has passed a declaration on various rights of ethnic, various religious and minority people. So on 18th December, because on this December United Nations has passed this charter which safeguards the rights of the minorities. So we generally observe 18th December as the Minorities Rights Day. So what are the constitutional and legal provisions related to the minorities? As we just discussed, there are many constitutional provisions, there are many legal provisions as well which protects the rights of the minorities. So in constitution, when we say we have fundamental rights mentioned mentioned in part 3 of the constitution, we have fundamental rights from article 12 to article 35. Major fundamental rights which protects the rights of the minorities are, like we have article 14 right to equality, we have article 15 prohibition of discrimination against on the basis only of religion, race and all. We have article 16 which ensures that equality is maintained in terms of employment. When there is an employment both in government and private also, there have to be maintained, the people have to given opportunity in terms of employment. So we have article 25 religious freedom. So article 25, 26, 27, 28, all this gives a religious freedom to the minorities. Minorities can establish their own educational institutions. A normal person can profess any religion. They have the conscience to practice, propagate and profess any religion. They could manage their own religious affairs. Managing religious affairs is that they can decide on the various aspects, like how much need to be denominated, what instructions should be taken when establishing the educational institutions or in the process of protection of their literature, language, culture, etc. So what are are the major constitutional and legal provisions we have? So we have this Act, National Commission for Minorities Educational Institutions, NCMEI Act 2004. This is a major act which which protects the various rights regarding the education. We have Article 15 and 16, very important when it comes to minorities. So as we said, Article 15 is prohibition of discrimination, Article 16 is regarding providing equal opportunity in terms of education. These articles we would be discussing in general. Article 25, 26, 28, these articles talks about right to religious freedom. Article 29, 30, cultural and educational freedom, like minorities, it protects the cultural and educational rights of the minorities. We have Article 350B, which talks about linguistic minorities. There is a special officer for linguistic minorities. So this commission, National Commission for Minorities, regarding educational institutions. Now, as we said, we have 6 religious communities. We have Muslims, Christians, Sikh, we have Buddhist, Zoroastrians and Jains. Recently in 2014, Jains has been included in the minorities list of minorities. So the term minority, what is the minority? So the term minority is actually not defined in the constitution, but it recognizes both religious and linguistic minorities. Linguistic minorities is the minorities based on the language. Religious is the religion what they follow. So this is Article 15. Article 15, the safeguard which guarantees the protection of fundamental rights of the minorities or of any other common citizen also. So on the basis of religion, on the basis of race, a person cannot be discriminated. So this becomes a very important article, which is a fundamental right. When I say fundamental right, if any action of the government or any private person breaches this right, then the aggrieved person could approach Supreme Court, person could approach High Court under Article 32 and 226. This we have discussed in our fundamental rights session. So Article 15 and 16 are important. 15 is prohibition of discrimination against citizen on grounds of religion, race, caste, sex and place of birth. This is Article 15. We have Article 16. Article 16 talks about employment, employment, giving equality of opportunity. So every person, irrespective of their religion, has to give an opportunity for employment. That is, they have to be taken in the employment process, be it government or private employment. So they have to provide opportunity for all sections of the people. That is Article 16. So they cannot just discriminate, they cannot just deny a person opportunity on the basis of religion, race and other things. So this is freedom of conscience. Freedom of conscience, Article 25. Any person can take any religion, not forcefully, but by conscience. That is, by his intuition, by his own conscience, a person can take any religion and he can openly propagate such religion. He is openly practice such religion. So no one is under pressure to adopt any religion, but can adopt a religion by his conscience. They can shift to any religion. So this is an important religious safeguard guaranteed by the Constitution under fundamental rights. So Article 25 talks about the freedom of conscience, the freedom to profess, propagate and practice religious activities. This is Article 26, which talks about the religious affairs, managing the religious affairs, be it from collecting funds, managing their religious institutions, managing their religious affairs and all. So Article 26 it guarantees the fundamental right to have their religious affairs and freedom to attend instructions. This we generally studied that in fundamental rights. We have discussed that they can create their own educational institutions which can promote their practices, religious practices. No one is forced to follow instructions, follow religious instructions, but voluntarily the religious practices can be followed, and the community, the religious community which has established such educational institutions will have a freedom to design their curriculum. So they can protect, in order to protect their culture, their literature, they can design the syllabi or the curriculum of such educational institutions. So we know Article 29 and 30 talks about protection of educational and cultural rights of the minorities. Protection of cultural rights. They can design any such program. They can promote their language. They can conserve their language. So they can also protect the religious minorities in terms of their culture, in terms of their language and literature. So Article 29 and 30 talks about the educational and cultural freedom of the minorities. So Article 30 talks about establishment of educational institutions of their choice. So they can also establish educational institution. So this is major thing which promotes the welfare and development activities in terms of education. So in terms to protect their own culture, identity, and to promote their education or to propagate the religious practices, they can establish such educational institutions. So Article 350B, we had a special officer for linguistic minorities, which is we have a constitutional status given to this. That is Article 350B talks about a religious linguistic officer, a special officer for linguistic minorities. Even this article safeguards the rights of linguistic minorities. So linguistic minorities, the officer will strive to safeguard the rights by investigating any complaints given to such officer. So that was National Commission for Minorities. It's a very important commission. It is not that the National Commission of Minority, which is not a constitutional body or which is not mentioned in the constitution, but it has a significant part, because National Commission for Minorities is a statutory body which has created by the Parliament. So Parliament, which is the highest authority, has created the National Commission for Minorities. So National Commission for Minorities is a statutory body. It's not a constitutional body, it's a statutory body. So as we know, how many members are there in National Commission for Minorities? We have a chairperson, vice chairperson and 5 members. In total, we have 7 members in National Commission for Minorities. One another important constitutional body, National Commission for Scheduled Castes. So this is a constitutional body under Article 338. So just to know the functions of National Commission for Scheduled Caste, its composition, various things related to the reports pertaining to the National Commission regarding Scheduled Caste and Scheduled Tribes to the President. We will be discussing what is the background of National Commission for Scheduled Caste. So there was a need for a National Commission. Before having a National Commission for Scheduled Caste and Scheduled Tribe as well, under Article 338, we had a special officer designated to look after the issues of both SCs and STs. So just will get into the matter. So as we know, we have a National Commission for both Scheduled Caste and Scheduled Tribe. We will be discussing this. First, we will be knowing a National Commission for Scheduled Caste under Article 338. So it's a constitutional body. It's a constitutional body created for the protection of interest of Scheduled Caste community, which have undergone through various things which have alienated them from the development. They have been kept out of the developmental process. So to have an inclusive growth, and to provide welfare, development and advancement to such section of the people, especially scheduled caste, the National Commission of Scheduled Caste has been created. So we have established this National Commission for Scheduled Caste under Article 338. It's a constitutional body established or created to protect the interest of the scheduled caste community in India. So, how it functions, what is the composition of NCSC. So, we have both NCSC and NCST, that is National Commission for Scheduled Caste and Scheduled Tribe. So, this commission provides, or it acts as a body, a quasi-judicial body also, where it will protect the interest of the SCs and STs. So, National Commission for Scheduled Caste and Scheduled Tribe will looks into the matters of investigation, that is wherever the government of India, that is both central government and various state governments, if any policy decisions to be taken which affects the lives of scheduled caste and scheduled tribe, such policy decisions should have a consultation. The government should consult this commission on various policy matters related to scheduled caste and scheduled tribes. And the major function is also to inquire into the specific complaints, because as we have seen, the depressed class or the underprivileged section of the society have faced many social discrimination, or they have faced many atrocities related things from various quarters or various sections of the society. So, as we know, SCs and STs have gone through various oppression in the history. So, there have to be a specialized body which looks into the complaints related to SCs and STs. So, here specifically when we talk about NCSC, this commission will inquire into the specific complaints regarding the process of development, regarding the socio-economic justice of SCs. So, it looks into the complaints which is concerned regarding the socio-economic development of the scheduled tribes. So, as we know, National Commission for Scheduled Caste is not originally created. We had a special officer. Designated as a commissioner for SCs and STs. But as time progressed, we had felt a need to have an exclusive body, exclusive constitutional body, a multi-member body which could looks into the matters of advancement, development, economic progress, justice related to the SCs and STs. So, initially we had a special officer who was designated as a commissioner for the scheduled caste and scheduled tribes. Then after 65th amendment, we have replaced this special officer by multi-member committee. Actually, special officer was a single member body. Then because there was a lot of demand to have a exclusive body, a multi-member body which looks into the matters related to the SCs. We had replaced this one member system with a multi-member system by National Commission for SCs and STs. There was a combined commission for both SCs and STs by 65th Amendment Act 1990. Then later by 89th Constitutional Amendment, we have separated National Commissions for SCs and National Commissions for STs. So, initially we had combined commission for both SCs and STs. As we know, STs are a different community. They have their own culture. They have their own geographical things. They related to forests. They live in isolated areas. So, obviously there is a need to have a separate commission for them. So, that is the reason why by 89th Constitutional Amendment Act we have separated national commissions for SCs and STs. Here, by 65th Amendment Act, we have replaced the single member special officer who is designated as a commissioner for SCs and STs. By this act, we have replaced that single member body by a multi-member body. Now we have in National Commission for Scheduled Caste and also in National Commission for Scheduled Tribes, we have a 5-member body, that is chairman, a vice chairman and 3 members. So by 65th Constitutional Amendment Act, we have replaced this 1-member system by multi-member system. So Article 338 now talks about National Commission for Scheduled Caste, and Article 338A National Commission for Scheduled Tribes. Again, see, by 89th Amendment Act, we have separated from 1990, that is here by 65th Amendment, from 1990 till 2003. There was a single body for both scheduled caste and scheduled tribes, but by 89th Constitutional Amendment Act, we have separated the National Commission for Scheduled Caste and National Commission for Scheduled Tribes. We have an exclusive national level bodies for both SCs and STs. So by 89th Amendment Act, this is an important amendment in year 2003, where we have 2 separate bodies for National Commission for SC, that is Article 338, and Article 338A talks about National Commission for ST. So it's a multi-member body at present. So it consists of chairperson, vice chairperson and 3 members. So we have in total 5-member body. Earlier, before 65th Constitutional Amendment Act, as we know, we had a single member body who was called as Commissioner for SCs and STs. Now we have a multi-member body because by 65th Constitutional Amendment Act, we have created a National Commission for SCs and STs. Both were combined in year 2003 by another amendment to the Constitution, that is 89th Constitutional Amendment Act. We have separated National Commission for SCs and STs. Now all these members are appointed by the President. So President of India will appoint all these members by warrant under his hand and seal. So this generally we have seen this in the appointment of Comptroller and Auditor General. CAG is also appointed by the President of India under his warrant. So here multi-member body appointed by the President. And one more thing here is the working conditions, the conditions related to emoluments, salaries and all will be decided by the President. So here it's an important thing, all those conditions are decided by the President, not to confuse. Here in National Commission for SCs and STs, all those privileges, conditions are decided by the President. So what are the major functions of National Commission for Scheduled Caste? Major functions. So what all the NCSC is have to do regarding the welfare, regarding the development, regarding the advancement, regarding the safeguarding the various provisions mentioned in the Constitution, protection of their fundamental rights, providing livelihood, giving the fruits of development to the scheduled caste people. So various things, right from welfare to development, all those processes are included in the functions of National Commission for Scheduled Caste. As we know, NCSC is also a quasi-judicial body. It has the power of civil court. It could issue summons to various bodies. It could ask for evidences. It could ask for reports from various agencies. But only thing is, NCSC is a recommendatory body, that is, it will advise the government. It will advise the government, or it recommends the government on various policy which affects the lives of scheduled caste. So the major functions what we generally expect the NCSCs to perform is monitoring and investigating all issues. So this is a very important thing, monitoring. How it monitors? See, the government of India or the government of various states will bring certain policies which which may have no positive effect, or which may also take away the rights of scheduled caste people. So to protect the interest of the scheduled caste community, the National Commission for Scheduled Caste will always monitor such actions of the government. As we have seen, the government will come and go, but the welfare practices has to be very balanced in way. So all the sections of the society should be able to get the fruits of development, and education, health, these benefits should reach every every citizen should enjoy the policies of the government. So here NCSC is it monitors and it investigates on all those matters concerned relating to the welfare and development of scheduled caste. So it's a constitutional body. So obviously, whatever the findings the NCSC has taken from various policies will report to the president, and those reports have to be tabled in House of the Parliament, and there will be a debate and discussion on such reports or such findings given by NCSC. So one is monitoring and investigating in all issues. There may be an issue relating to the atrocities on SCs, or various issues, maybe land alienation. When there is a developmental project, the SC community would generally suffer because they have very limited land. Related to the land, related to the employment, related to the promotions, related to the reservation of seats, related to education, health and all. So all these matters would be monitored and investigated by the commission. So inquiring into the complaints, one is suo motoli the National Commission will generally take, but also if there is any complaint regarding to any issue, on such complaints also National Commission for Scheduled Caste would act. So on the rights issues, generally most of the matters or most of the complaints are related to the rights. That is when the rights of the SCs, that is maybe fundamental rights or any human rights related to violation of human rights related to SCs, they will lodge complaints. So NCSC will generally inquire into such complaints. As we know, NCSC has a judicial power, that is, it's a quasi-judicial body. It has the power of civil court, so it could issue summon, it could issue notice, it can also order to provide various evidences or various reports related to such complaints. So generally on the deprivation of the rights and safeguards of SCs, the NCSC would work. Taking part and advising the central or state governments. As we know, central government or state government will come up with various policies which affects the life of SCs, maybe by providing health facilities, or construction of houses for them, or giving lands for farming, or on various matters related to subsidies or providing bank loans. So on all these policies which has effect on the lives of scheduled caste, both related to welfare and development in all the sections, all the sectors related to health, education, agriculture, manufacturing and all. So on various policies, the members of the National Commission of Scheduled Caste would generally participate, or the government would make them participate in the framing of the policies, because they need to have a special reports, special ground realities related to SCs, how the policies would work, what should be the process of the policy. So regarding the socio-economic development, regarding the planning of such policies, the NCSC will take part, or they will advise the governments related to the policies which affects the lives of SCs. and reporting to the president whatever the findings are there, which have findings related to any investigation, related to working on the complaints of any person who has deprived his rights. So all those findings should be reported to the president regularly, so that all those reports will be taken into the consideration in framing of the policies, or in bringing any law which could protect the interest of the SCs. So the commission will report to the president on various matters. So it also recommends on various steps to be taken for the welfare and advancement of the SCs, that is socio-economic development and other welfare activities. When we say socio-economic development, it is the basic thing. The constitution obviously has given political power, that is the SCs and STs can participate directly in the elections, but the thing is, the government have to take certain steps which could improve the lives of the people. As we know, SC community have faced a lot of discrimination. So the government has to ensure that such discrimination shouldn't be continued in this modern world. So socio-economic development should be taken in planning various policies or framing various schemes for the advancement of SCs. So on those things, the government would generally take advices from this specialized body. And any other function with respect to the welfare, protection, development and advancement of SC community. Protection, development, like all the sections, girl, child, students, old age people, farmers, urban people, to help them to establish their own businesses, right from small micro industries, or giving loans for self-help group people on low interest. So all those policies and programs have to be taken by the government of India, and in that process the National Commission for Scheduled Caste would advise the government. So this till 2018, even the functions or the duties related to the discharging of the functions of OBCs also with the NCSC, but now it has relieved from such duty by 102 Amendment Act. So the same thing, now this commission, National Commission for Scheduled Caste, would also look into the matters of Anglo-Indian community. So the commission will present its annual reports to the president. The president would in turn place such reports in front of the houses of the parliament, and parliament would debate and discuss on such reports. And the recommendations of the National Commission for Scheduled Caste generally is taken by the government of India or any state governments. Generally the recommendations are accepted, but in case if those recommendations are not accepted by the government, then the government have to give an explanatory note on why the government have not accepted its recommendations, because as we know, NCSC is a constitutional body, a specialized body, and it's a multi-member body. Then there have to be a reason why the government has not accepted. It's not that the recommendations are binding on the government. The government may or may not accept all or some of the recommendations made by National Commission for Scheduled Caste or scheduled tribes as well. But as it's a constitutional body and constituted for the welfare and development of the SC community, the government has to accept the recommendations. In case if there is any deviation, then the government have to give an explanatory note on why such recommendations are not accepted. So on non-acceptance of such recommendations, it has to give reasons for non-acceptance. So, if the recommendations are related to the central government, then the NCSC would give its reports to the president, and the president in turn, if the recommendations have also effect on state governments, then such recommendations are submitted to the state governor. Every state has their own section of the population. It depends upon the proportion of the population. Few states have more SC population, few states have lesser SC populations. So depending upon the population, depending upon the nature of problems the community is facing, various state government would derive their own policies. So the commission is as we know, it's a quasi-judicial body. It has vested with powers to regulate its own procedure relating to its procedure. It will investigate. It has their own staff, and as we know, it's an important thing that it acts as a civil court. The power we have with the National Commission is the power of civil court, which is very important to issue summons, to call for evidences and all. So summoning or enforcing the attendance of any person. So as it has the power of civil court, the commission will summon people to come before the commission and to give the explanations regarding any complaint, or the commission can also ask for providing the evidences, reports related to the matters which has deprived the rights of SC community. So it could summon, it could enforce the things related to the issues or matters of investigation regarding SCs, requiring the discovery and production of any document, evidence, or any such report related to the SC community. So receiving evidences on affidavits, requesting any public record from any court where there is a requirement in providing or safeguarding the rights of SC, the National Commission for Scheduled Caste can request the public authority to provide for such documents. So examination of witnesses, this is again a very important thing, because we know generally what happens is the National Commission would inquire into such complaints where the persons of scheduled caste has faced discrimination, or they might have deprived of their rights. In such matters, the commission would also ask the authority to conduct investigation on such matters, or suo motoli the National Commission for Scheduled Caste could examine or summon such persons related to the evidences and documents. All these reports should be decided or should be presented to the president, and the president can also ask the commission on various issues. So not only these functions, the president may also ask the National Commission for Scheduled Caste on other matters from time being related to the welfare and development or protection of rights of scheduled caste. So this was the National Commission for Scheduled Caste. We'll just have a brief understanding. We'll have few questions related to the NCSC. So question is, National Commission for Scheduled Caste is it's a statutory body, constitutional body, multilateral institutions, both A and C. See, when we say multilateral or multi-body institution, here the National Commission for Scheduled Caste is a constitutional body. As we know, it's a constitutional body under Article 338. And it's a multilateral. Here when we say multilateral institutions, one is it's not a single member body. It is composed by 5 members, that is chairman, vice chairman and 3 other members. See, it's a multilateral institution in the sense that it has a power of judiciary. It's a quasi-judicial body. It could ask for any other agencies in the process of functioning. It could also take help of other investigative agencies. It will advise the central government, state government on various issues related to scheduled caste. So here the answer is A is wrong, because it's not a statutory body. It's not created by the Act of Parliament. It's a constitutional body. So answer would be both B and so here in this option we know there is Answer C is also correct, but here in this option we have only one answer, that is constitutional body. It's a constitutional body, so answer will be B. When we take second question, who is the current chairman of the National Commission for Scheduled Caste? It's Vijay Sampala, who is the chairman of the National Commission for Scheduled Caste at present. Which Scheduled Caste Commission? The Scheduled Caste Commission is defined under which article? As we know, it's under Article 338. We have National Commission for Scheduled Caste, and 338A, this is related to the National Commission for Scheduled Tribes. So how many members are there in the National Commission for Scheduled Caste? So we have a chairman, we have a vice chairman, and 3 members. In total, we have 5 members in NCSC. So the total members are 5. We have chairman, we have vice chairman, and we have 3 members in the National Commission for Scheduled Caste. Who appoints the chairman of the National Commission for Scheduled Caste? As we know, President is the appointing authority. President appoints the chairman and members of the National Commission for Scheduled Caste under his seal and warrant. So it's an important thing. We have a president who is the appointing authority. Which article deals with the functions of the National Commission? In under Article 338, we have various clauses also. So 338 talks about the establishment, that is about the National Commission for Scheduled Caste, and it's 338 clause 5, where the functions of National Commission for Scheduled Caste are mentioned. So we have to remember the subclauses and various functions of this commission. Separate commission for scheduled tribe. We had a 65th constitutional amendment. By 65th constitutional amendment, we have created this multi-member body. Before that, we have a special officer for scheduled caste and scheduled tribes, who was designated as a commissioner for SCs and STs. Then as we have a requirement to have a national level body, to have a multi-member body, we had by 65th constitutional amendment created National Commission for Scheduled Caste and Scheduled Tribe under Article 338. Then by 89th Constitutional Amendment Act 2003, we have separated National Commission for Scheduled Caste and Scheduled Tribe, because as we know, ST is a different community which has their own culture, their geography, that is the places they live is also isolated, so they have their own problems, own law related to land, forest, their culture, and that has made to create a separate community or separate commission. We have separated the National Commission for SC and ST. So in this lecture, we will be discussing the composition, the functions of NCSC, and what are the challenges we have. So National Commission for SC here, we had a integrated commission for both SC and ST before 89th Constitutional Amendment. So here the National Commission for ST, here ST is a constitutional body under Article 338A. Article 338 talks about National Commission for Scheduled Caste. 338A is National Commission for Scheduled Tribe. So as we know, why we felt a need to have a separate body, that is separate commission for scheduled tribe, because they are different from SCs. SCs have they have their own problems. STs are different culturally, they are different, they live in an isolated area, they have different problems in total. So we felt a need of having a separate commission, and also as we said, there have to be a development, there have to be equal development for all sections of the people. And for STs, generally STs are isolated, they live in isolated places, agency areas, and the government has to protect their rights, because generally they are very innocent people. They could be easily manipulated by the people. So various forest regions in which we have a lot of mineral resources, so private people could easily enter into their places for natural resources, and in that process they could be they could, their cultural cultural things could get disturbed. Their identity could be disturbed by such developmental activities. So in that process, to ensure that the government protect the rights of scheduled tribe people, tribals, and also to make them part of the development, to protect their rights, to promote their welfare, to bring them in mainstream of development, we have created this National Commission for Scheduled Tribe, which looks into the matters of tribals. So in 1999 we have a Ministry of Tribal Affairs. It's a nodal agency which works on the advancement or welfare development of the STs. So as we know, National Commission was for ST, National Commission for ST by 89th Constitutional Amendment Act. We have separated from National Commission for SC. Now we have a body which have which exclusively works on the matters of tribals. So when we discuss National Commission for SCs, we have a very similar function related to STs as well, and the composition is also very similar. We have a chairman, vice chairman, and 3 other members. In total we have 5 members appointed by the president. So related to the structure of the commission, we have 5 members: chairman, vice chairman, and 3 other members. So at least 1 member should be a woman. This is the composition because we also have very sensitive issues related to the matters of women rights. So we have made it that at least 1 member should be women. So they have a term of 3 years, and the members are not eligible for more than 2 terms. This is to ensure the independency of the commission, to ensure that the commission is a dynamic entity. It functions in a very dynamic manner. So we have limited the term to 2 terms. So the chairman has given a rank of cabinet minister. This shows how important the commission is, because whatever the recommendations made by this commission to the government has to be taken very seriously, because it's a constitutional body. The members are experts in the matters related to the governance, related to the administration, related to the society of tribals. So definitely the recommendations whatever advised by this commission will be accepted by the government, and that is the reason why the members, the chairman has been given a union cabinet minister's rank, and ministers of state rank given to the vice chairman. So the functions are similar. The functions are similar to the functions of National Commission for Scheduled Caste. This we have discussed in our just previous class, to investigate and monitor all matters related to the rights, related to the issues of matters of scheduled tribes. So to safeguard and protect the fundamental rights, natural rights or human rights of tribal community, and it also investigates on various matters or various complaints which has the complaints related to the violation of fundamental rights or any rights of tribal community. As we know, generally tribals are more face more problems related to land alienation, because tribal communities live in an isolated area. Most of the tribals live in forest areas, and whenever the government undertakes any programs, any developmental programs, maybe related to any irrigation project or a thermal project or afforestation. So, in these issues, the tribal community would face problems related to the land alienation or rehabilitation, resettlement. All these things generally concern the tribal community, as we have seen many developmental programs in forest areas or mining activities for natural resources. In this process, of governmental programs, the tribal community would face many problems. So all those issues is taken by National Commission for ST, and it recommends the government on various matters related to rehabilitation, resettlement or compensation. National Commission for ST is involved in this process. It inquires into also specific complaints with respect to deprivation of rights regarding the tribal people. It also participate and advise in the planning, because there have to be a planned development in such areas. The government have to take many developmental schemes. So in that process, for both providing welfare and developmental programs to the tribal community, it will also advise the government on various process regarding to the plan development, socio-economic development, and it evaluates the progress of their development. Here the National Commission for Scheduled Tribes also does not only recommend on various matters, it also evaluates the functioning or the performance of such programs which has effect on tribal community. So it also report to the president. It submits its report to the president, and it recommends on various matters which generally works on the evaluation and performance of various programs undertaken by the governments for effective implementation of such programs which has effect on rights or development of tribal community. So, to protect their fundamental rights, to promote their welfare activities, to have an equal development, to provide justice to such community, the National Commission for ST would function. It also discharged the functions related to various matters which have an effect on tribal community related to their advancement, their development and other issues. So all these things, all these recommendations, all these findings would be presented to the President of India, and these reports in turn the President will submit or place in the Houses of Parliament, on which the debates and discussions would happen. Generally, the recommendations of the National Commission for ST are accepted by the government. In any case, in such non-acceptance, the government should give the explanation or to provide explanation on such matters for non-acceptance of those recommendations. So, in the matters of non-acceptance of such recommendations, the government should explain the reasons. So, if the matters are concerned with the state government, such reports are submitted to concerned state governor. So, as we know, this commission has a power of civil court. It's a quasi judicial body similar to the National Commission for SC. It also regulates its own procedure. It will act as a civil court, that is, it could summon the persons, it would ask for the evidences, it could also ask for the documents from other public authorities. So, it has the power of civil court. So, whatever the power we have discussed in National Commission for Scheduled Caste, it is similar here also. It would summon or enforce the attendance of any person required where there is complaint filed. So, receiving evidences on affidavits or requesting any public record from any court related to the matter of deprivation of rights of tribes, that is National Commission for Scheduled Tribes. So, these are similar things. So, National Commission for Scheduled Tribes is a constitutional body. As we have discussed, it's a constitutional body. Now, the present chairman of National Commission for Scheduled Tribe is Harsh Chauhan. It's a current affairs or GK question. At present, we have Harsh Chauhan as a National Commission, Chairman of National Commission for Scheduled Tribes. National Commission for Scheduled Tribes is mentioned under Article 338A. So, A, this is amendment, 9th Constitutional Amendment 2003 has separated National Commission for Scheduled Tribes from SC. We had a single commission for both SCs and STs. By this amendment, that is 89th Amendment, we have separated this. So, Article 338 talks about National Commission for Scheduled Caste and 338 about National Commission for Scheduled Tribes. So, we have 5 members in total, 1 chairman, 1 vice chairman and 3 members. So, in total, similar to National Commission for Scheduled Caste, we have 5-member body. Who appoints the chairman of the National Commission for Scheduled Tribes? It is the President. President is the appointing authority under his warrant and seal. So, President appoints the chairman and members of the National Commission for Scheduled Tribes. A non-constitutional body, a statutory body, very important organ, National Human Rights Commission. As we know, it's a non-constitutional body. National Human Rights Commission is not a constitutional body. It is not mentioned in the Constitution. This commission, National Human Rights Commission, is a statutory body. That is, it has been enacted by the Act of a Parliament. It has enacted by the Act of Parliament, and it has a composition, very powerful composition. Even the chairman and members of National Human Rights Commission are appointed by a body headed by the Prime Minister. The National Human Rights Commission, its chairman, members, composition, term of National Human Rights Commission, various privileges to the chairman and members of the National Human Rights Commission, what are the various roles to play by the National Human Rights Commission. We will be discussing this in our class. So, we'll start National Human Rights Commission. So, as I said, it's a statutory body. We have discussed earlier the difference between the constitutional body and statutory body. When we say statutory body, it is enacted by the Act of Parliament. So, a resolution is passed into the by the Parliament, by both the houses of the Parliament, and it has to be given assent by the President. So, through a parliamentary procedure, this body is enacted. Because it is set up by a statute of the Parliament, we call it as a statutory body. National Human Rights Commission is established in year 1993 by the Act. We have an Act called Protection of Human Rights Act, PHRA Act 1993. So, by this legislation, Protection of Human Rights Act 1993, we have created National Human Rights Commission. So, what is the significance? Why we should have a National Human Rights Commission? Because we know wherever there is a power, wherever there is a government, obviously the people may get affected by various reasons, acts of government or any private acts also. So, to protect the values of human, that is humans' rights, their duties, we should have a autonomous, independent, a powerful body which could act as a protector of human rights. So, we have Paris principles. So, on basis of international agreements, international conventions, we have established this National Human Rights Commission. As we know, we have Constitution. Constitution is the source of power for all the organs of the government. Majorly, we have legislature, executive and judiciary. All these organs of the government derive their power from the Constitution. So, in the process of the governance, government may come up with several policies which may it sometimes affects the human rights also. As we know, we have fundamental rights. We also have directive principles of state policies. And wherever the government comes with such policies which affects the fundamental rights, the aggrieved person can move Supreme Court or High Court, and Supreme Court and High Court has the power to issue writs. So this power of the Supreme Court to issue writs regarding the protection of fundamental rights of any individual. In the same way, we have a separate body, a Human Rights Commission, where any act, be it private act or the act of the government, which hurts the human rights, that aggrieved person can go through petition to the National Human Rights Commission. The other way also, National Human Rights Commission can by suo motu action take such cases. There may be many cases. For example, if someone is detained illegally and jailed, so in that, if there is a question of violation of human rights, like we have custodial death or custodial tortures, that cases can be taken by the Human Rights Commission, or the living standards of the inmates in the jails, or we have tribal rights or any such human rights like violation of women's dignity or forceful compulsion or forcefully human trafficking or prostitution. Many cases are taken by the Human Rights Commission suo motu or by any petition. On the basis of petition also, Human Rights Commission will take such cases. So in India, we have National Human Rights Commission and headquartered at Delhi, where NHRC is located. So basic thing is the Human Rights Commission. Human Rights Commission works for the protection of human rights of the citizens. Everyone, be it from child to women, elderly people, any person who has a complaint of violation of human rights by any authority, be it public or private, may approach National Human Rights Commission for the protection of their natural rights, that is human rights. So other than the fundamental rights which is enshrined in the Constitution, and the Supreme Court is the custodian of the Constitution. So aggrieved person can move Supreme Court where their fundamental rights has been violated. In the same way, if the human rights are violated, we have an autonomous independent agency which tries to protect the human rights by recommending and suggesting various parameters to the government. It's importantly an advisory body, and the recommendations of the National Human Rights Commission are generally taken seriously by the government. So NHRC is a watchdog, that is protector, guardian, custodian of human rights in the country. So human rights may be related to various things. As we know, we have done our classes on fundamental rights. We have done our classes on preamble also. So in preamble, we see this right to life, liberty, equality, dignity. These all things we generally study when we are doing fundamental rights. So other than the Supreme Court, which is the custodian of the Constitution, we have a Human Rights Commission which will look after the protection of human rights regarding these things, right to life, right to liberty, equality, dignity of individuals. So how the National Human Rights Commission would function in general? So the main purpose is to strengthen the institutions, to strengthen various institutions involved in the governance of the country. Because as we know, we have two important things. Even our preamble also says that we are a country where we are secular, we are socialistic, we are democratic, we are republic. So in the process of protecting such things in our day-to-day life, institution should have a very autonomous things. A powerful institution should function to protect the rights of the humans. So the National Human Rights Commission here tries to strengthen all those institutional arrangements which becomes a part in the governance of the country. So here to strengthen the institutional arguments, when we say every institution, right from judiciary, legislature, executive bodies, constitutional bodies, statutory bodies, all these bodies are here to to welfare of the people. They work for the welfare of the people, they work for the development of the nation. So in the process of governance, there may be few cases where human rights may be violated. So such actions of the government which violates the human rights would be taken by the National Human Rights Commission. So there may be excess of any work. Otherwise, we can say that the government may bring up with a project which will generally alienate the people, or there may be a requirement for a big project by the government where the farmers have to give away their lands without compensation. So such issues will be taken by the National Human Rights Commission. So we can say that to look into the allegations of excesses. Here excesses is any action which generally has a threat to the people, and these actions of the government are looked by the Human Rights Commission, and taking the overall view of the national human rights. So it is independent of the government. The actions of the National Human Rights Commissions are independent of the government, and because of the composition what we have in the National Human Rights Commission, we could easily say that it's a powerful body, because the chairman of the National Human Rights Commission is generally a retired Supreme Court Chief Justice. So retired Chief Justice of India is a chairman of the National Human Rights Commission, and various other members. We have 5-member body. One is a chairman and 4 members. Other 4 members are like we have retired Chief Justice of High Court or Judge of the Supreme Court, and 2 other persons have a specialized knowledge on various factors like knowledge on human rights. So we will discuss that in our coming slides. And one thing is to complement and strengthen the efforts of various other bodies. So here we talk about the composition of the National Human Rights Commission. So it is a 5-member body. The composition is 5-member body, 1 chairman and 4 members. We also say that we have 6 other members also, 6 ex-officio members. We will discuss that. See, one is chairman. That is chairperson should be a retired Chief Justice of India. So a retired Chief Justice of India, who is the highest dignitary. We know Supreme Court is the apex court. It's the top court in the country, and Chief Justice is the head, that is the ultimate judge of the Supreme Court. So the Chief Justice of India, after his retirement, can become the chairperson of National Human Rights Commission. So one member has to be a judge of the Supreme Court. Again, a retired judge. Here a chairperson should be a Chief Justice of India. One member should have been a judge of the Supreme Court, and one member Chief Justice of High Court. At state level, we have high courts. So one member should be the retired or has been the Chief Justice of the High Court. We have 2 other members who have specialized knowledge and experience in the subject called human rights. So one is chairman, one is a retired judge of the Supreme Court, one is a retired Chief Justice of the High Court, and 2 members who have experience and knowledge on the subject of human rights. So we have 5-member body. One is chairman and 4 members. So we have ex officio members also, 4 ex officio members in this National Human Rights Commission, and because National Human Rights Commission involves everyone, and when we generally say the violation of human rights, we generally consider that human rights are violated to most of the cases are for the underprivileged section of the society, minorities, SC, ST, women, children. So these population, the proportion of the population should also have a representation in National Human Rights Commission, and that is the reason ex officio members are the members, that is chairman of National Commission for Minorities, National Commission for SCs, National Commission for STs, National Commission for Women. So the chairman of these commissions will also act as ex officio members of National Human Rights Commission. So here we can say that we have 5 permanent members, 1 chairperson and 4 members of the National Human Rights Commission, and we have 4 ex officio members of National Human Rights Commission. When the National Human Rights Commission was amended in 2006, the members of these National Commission for Minorities, SC, ST and Women have also given a prominent position in the composition of National Human Rights Commission. So, we all know that appointment of chairperson and members of the National Human Rights Commission are appointed by the President. President is the highest executive, he is the head of the nation. So, the President appoints the members and chairperson of the National Human Rights Commission. So, these members, the members, ex officio members, again are recommended by a 6-member committee. So, it is not that, as we generally know, the President would appoint various dignitaries, various constitutional heads on the recommendation of the President, or Council of Ministers headed by the Prime Minister. So, President would make appointment on the recommendations of Prime Minister, who heads Council of Ministers. But here in National Human Rights Commission, the recommendations are made by a 6-member committee, exclusively made for the recommendations to choose such persons who are eligible for the National Human Rights Commission. So, we have a 6-member committee here, and we need to know who are the 6-member committee. The 6-member committees are headed by the Prime Minister. We have a Prime Minister in that panel who selects the candidates for the National Human Rights Commission. So, we have Prime Minister who heads this panel, 6-member committee, and in that panel we have Speaker of the Lok Sabha. So, Speaker of the Lok Sabha, Deputy Speaker of the Rajya Sabha. We know who is the chairman of Rajya Sabha. Here we can say in Rajya Sabha we have a chairman and vice chairman or deputy chairman. The chairman is Vice President of India. So, here we will take deputy chairman of the Rajya Sabha. We have leader of oppositions in both houses. That is both Lok Sabha and Rajya Sabha. In this panel, we also consider the persons from opposition party also, because it has to have a very comprehensive members who could select the members in the members as members of Human Rights Commission. So, we have leader of opposition in both the houses. We have Central Home Minister also. In this panel, we have Central Home Minister. So, these are the 6 members, and the sitting judge of Supreme Court can also be included in the appointment committee, but by the prior permission of the Chief Justice of India. So, this is an option. We have 6 members panel: Prime Minister, Speaker of the Lok Sabha, Deputy Speaker of the Rajya Sabha, Leader of Opposition. Here 2 members here from both the Lok Sabha and the Rajya Sabha, and Central Home Minister. So, these are the 6 members who are part in the appointing panel. That is, these people will select the members and chairmen of the National Human Rights Commission. So, when we say the salaries or privileges, emoluments given to the National Human Rights Commission, the central government would decide on this. That is, the central government of India, the central government. So what is the term or duration of the National Human Rights Commissions for both members and the chairperson? So the chairperson and members would have a term of 5 years or up to the age of 70 years. We need to understand this, up to the age of 70 years, because the chairperson and members are retired members. So after their completion of the age of 65 years in the service, then we have given 5 years term, that is up to 70 years there they would function as a chairman and the members. We have a term of 5 years or until the age of 70 years. And as we know, once they complete their term, both chairman and members, once they complete the term of 5 years or they attain the age of 70 years, they are not eligible for further employment. It is like similar to CAG, Comptroller and Auditor General of India, who is also not eligible for further employment, because there has to have a independency in their functioning. So they are not eligible for further employment under any government, be it central government or state government. So they can also be removed. The members of the National Human Rights Commission can also be removed by the president on various basis. Like there is no parliamentary process as we generally have in the removal of various constitutional dignitaries like Election Commission of India, CAG, Finance Commission and all. We can, like National Human Rights Commission, chairman and members can be removed by the president on the basis of adjudged insolvent. That is, they have been adjudged insolvent, any bankruptcy or any other allegations on them, or if they are employed when they are in the National Human Rights Commission within the term, if they are employed outside. Otherwise, we can say that if they are interested in some other things like business or any other employment, they could be removed from the office. So these are other reasons here on the basis of removal of the National Human Rights Commission. We can say that unfit to continue, or if they are infirmity physically and mentally, they can be removed by the president. That is, if they are unfit to continue or infirmity of mind or unsound mind, they can be removed. Or if they are convicted in any offense or they have faced any imprisonment also, they can be removed by the president. The functions of National Human Rights Commission. One important thing is, when we discuss National Human Rights Commission, we need also to know that there are there is a provision that every state should have a State Human Rights Commission. Though the composition is slight different, in a State Human Rights Commission, we have a chairman and 2 members. In National Human Rights Commission, we have a chairman and 4 members. And the term is similar. We have a 5 years of term or until the age of 70 years. So here in this class, we would be discussing what are the role of National Human Rights Commissions or the functions of National Human Rights Commissions. So the important function is, the National Human Rights Commission will inquire into the matters of violation of human rights. Here human rights can be violated by concerned governments or any such public authority. Wherever a common man or an individual or a group of people thinks that their rights have been violated. Here when I say rights, if the rights are fundamental rights, they could approach the court. If not the court, Supreme Court or High Court, if any other rights, any other natural rights of human beings are violated, they could approach National Human Rights Commission or State Human Rights Commission if the subject is under the state list or concurrent list. As we know, we have 3 lists in a federal system. We have a union list, state list and concurrent list. National Human Rights Commission would inquire into the matters of union list or any other such things, and state Human Rights Commission which has to be established in every, just to understand the role, the significance or the importance of National Human Rights Commission, we would be knowing the functions of National Human Rights Commission. So, inquire into the violation of human rights. So, anything, any action of the state or any action of public authority, if the actions violates the human rights, then the National Human Rights Commission, which has its own investigative body, or it can also take the help of other investigative agencies of the government and inquire into such cases. Important factor here is the National Human Rights Commission is a quasi-judicial body. As we know, it has the power of a civil court. It could issue summons, it could ask from the government on various information regarding the policies of the government. Are such actions of the government which have violated the human rights of the citizens? When we say the violation of human rights, generally what happens is the human rights are mostly violated in criminal matters. That is, the inmates can be jailed without proper procedure. That is, without proper prosecution, any person could be sentenced to jail or held capture in jails. So, there is obvious a violation of human rights. Otherwise, also we can have many other civil cases, like if the government constructs a project where there is a land alienation, or if the government takes away land from the people without proper compensation, even there is a thing of human rights violation. In such cases also, the victim could approach National Human Rights Commission. Most of the cases where the National Human Rights Commission would interfere is where we have bonded labor, where we have forced trafficking of women, children, or we can also say that where there is a matter of insurgency, there is a matter of terrorism, like we also have very stringent laws like TADA. Like POTA, we have terrorist and destructive activities, we have prevention of terrorist activities. So, these law of the government are very stringent, where most of the innocents may also at times would face punishment without proper investigation or without proper prosecution. So, in that case, the National Human Rights Commission could suo moto take such cases or act on the petition of the victim. So, main thing is National Human Rights Commission will inquire into such violations of human rights which has to be protected in general by the state government, but in some cases the state government's action may take away the natural rights of common citizen. So, the actions may be by public servant. If the public servant action could, if takes away the natural rights of the people, then also the National Human Rights Commission, that is NHRC, would interfere. It can also take the cases on its own. So, suo motoli also National Human Rights Commission could take the cases. Generally, if there is any case which has wider publicity, for example, we have many cases of rape, torture or custodial deaths. In that cases, there is a lot of publicity in media, in electronic media, in print media, or even on social media, that is platforms of social media. So, that cases can be taken by the NHRC, and the NHRC would also take cases by petitions presented or filed by the victim. So, the victim, they themselves can file the cases, or any party on behalf of that victim can approach National Human Rights Commission. Generally, we see many pressure groups or NGOs, non-governmental organizations, or any sympathetic group would approach National Human Rights Commission for the protection of natural rights of a citizen. So, one is inquiring into the violation of such allegations or such violation of human rights. The National Human Rights Commission, NHRC, would also intervene in proceeding involving allegations of violations. So, For example, we have a big case of rape, torture. For example, we had a case of Nirbhaya in Delhi. So, in that, the National Human Rights Commission can also intervene in the proceedings, because it is established to protect the human rights or natural rights of the people. So, it could also intervene in the process of inquiry or process of prosecution, or it can also recommend the governments, concerned governments, either the central government or state governments, on how to prepare a policy. If the policy contains any matter which have intention or which could violate the human rights of the people, in that also the National Human Rights Commission can intervene. Only thing is, NHRC primarily has a recommendatory role to play. So, National Human Rights Commission cannot compensate anyone on its own. Neither the National Human Rights Commission could punish person. So, it can only recommend the government on its various process. So, it intervenes in proceedings involving allegations of violations of human rights. Generally, we see that in central prisons or jails, there are many cases of violation of human rights. Without proper trial, without proper prosecution, many persons are jailed. So, in that there may be a lot of human rights violation, there may be a torture, custodial torture, or there may be things of violating their natural rights. Such rights, to restore such rights, the National Human Rights Commission would work. So, in this process, the National Human Rights Commission, their members or any such dignitaries could visit jails or detention centers, to know or to ensure the living conditions of such inmates. Because we generally see that in such places only, in jails, detention centers, there is a lot of violation of human rights. This is an important function to review the constitutional and other safeguards. When we say human rights are violated, there might be some loophole in the constitution, or there might be some agency which is working against the spirit of the constitution. So, broadly speaking, we have to know, we have to understand how the agency works, how the governance works, what are those loopholes where a person or a normal person there is a chance of getting their human rights violated. So, to review the constitution, the National Human Rights Commission also studies on various matters regarding the safeguards of such agencies to protect human rights. So, to review the constitution and make proper recommendations to the president regarding such matters which could restore the human rights, or which could minimize the violation of human rights in the process of governance. That is one thing. And we also have to know that to review the factors including the acts of insurgency, terrorism. In many sensitive areas, we generally see that there is a lot of extremism, there is a lot of insurgency in northeastern states of India. We also see that there are many stringent laws. For example, we have armed forces law. So, those laws will empower the personnel, that is army personnel, to enter any house, any premises without prior intimation or without any warrant. They could arrest anyone, because those are the sensitive areas where there is a lot of law and order violation. So, in that process, obviously in the interest of the larger section of the people, or in the interest of the national security, the army forces may have more power, to search, to arrest, to detain such persons. So, in that cases, there may be a chances of human rights violation. As we have seen, APSPA is a special power given to the army personnel to detain any person without a proper arrest warrant. So, to study such laws, to study such stringent laws of the government where there may be a chances of violation of human rights, as we have seen in Manipur, there is a lot of public protest to repeal such draconian law of the army. So, to review the factors including the terrorism, we have seen terrorism, we had many stringent laws like we had TADA, we have POTA. So, these are the things which were very stringent, which had a lot of law or bylaws which could arrest a person without a proper warrant or could detain them under the Preventive Detention Act. So, these are few laws which had to be reviewed, and National Human Rights Commission have given very good recommendations to minimize the things which could violate the human rights. So, because the National Human Rights Commission is again inspired from the international protocol, like we had many agencies where national human rights of the people are given more priority. So, the NHRC would also study such treaties, and it would recommend the government on such treaties, because it's a very dynamic process. Earlier we used to just cherish the constitution or the actions of the states, but here the significance or the focus now is given on human rights. So, it could be anything, the property, the functions of any common man, the businesses and all. So, the National Human Rights Commission would also study the treaties and other agreements. We make agreements with other nations. We have bilateral agreements, we have multilateral agreements, we have various other international groups which strengthens the bond between the countries. So, the NHRC would also study on such agreements and recommend to the government on various factors. So, to study the treaties and other international agreements on human rights across the world, that is international institutions. And it also does work, that is research work. Because it's a very vast subject. Human rights are not similar across the world. We would be generally seen that in democratic countries, the natural rights of the people, that is human rights, are more to be taken care of. In some other countries, we would be seeing in dictatorial countries there is a lot of violation on human rights. So, depending upon the political system of the country also, the human rights would function, depending upon the system of the government, depending upon the nature of the ruling of the government also, we would be seeing the violations of human rights. So, the National Human Rights Commission would also study and make research in such programs in the field of human rights. So, to promote the human rights, the NHRC would also do the research work, because to just make a recommendations, it has to have a very deep understanding of human rights and its violations across the world. So, we could expect a very good recommendations, or the government should accept such recommendations on very rational approach. So, it will undertake the research program in the field of human rights. One more thing is we need to generate awareness. Awareness has to be spread among the people. Everyone has to know about their rights. Then only there is a deterrent type of thing, that the government could not come with such policies which could take away the human rights or their fundamental rights. So, to spread the knowledge, to spread the awareness of human rights, the National Human Rights Commission will also take up such programs which could promote the awareness regarding human rights to the citizens. It also encourages, the National Human Rights Commission, which is a statutory body, which also encourages other such agencies. We could see that the government cannot do all the work. So, we have some non-governmental organizations also, voluntary groups or pressure groups, which will act in behalf of the people, or the NGOs or other pressure groups would try to protect the human rights of such citizens. So, it is also the function of the National Human Rights Commission to encourage, to support, to strengthen such non-governmental organizations or any other pressure groups which works for the protection of human rights in the country. So, to encourage the efforts of NGOs, NGOs are non-profit and also non-governmental organizations which work for the betterment of the society. So, it is also the duty of the NHRC to promote and encourage such NGOs which are working towards the protection of human rights in the nation, and also to undertake such other functions where the human rights are to be protected or to minimize the violation of human rights. We cannot generally say that human rights can be restored 100%, or the state action in sometimes may for few people it may take away their human rights, but in general the NHRC would try to promote and protect the human rights, and in that process it would take many other functions which deemed necessary. So, as we say, National Human Rights Commission has the power of civil court, that is, the Human Rights Commission can summon people, can give notices, it could act as a civil court. But one thing to say here is, here the National Human Rights Commission will not punish on its own. So, it will be recommendatory in nature. It recommends the government on such punishments. Though it has its own investigative agency, NHRC can also take the help of other investigative agencies in the process of investigation of such acts which violates national human rights or human rights of the people. So, it will follow the process of a civil procedure code. So, in this process it acts as a quasi judicial body or a civil court. So, civil court's power means it could summon, enforce attendance of such officers, or it could ask for the documents, material documents or evidences where there is a violation of human rights. And it also tries to take the evidences, that is production of any documents or having filing of such documents which has effect on violation of human rights. So, these are the powers of Human Rights Commission. It can also demand a record, because in bureaucratic system or in any such other system there is a lot of there is no transparency. Obviously, after a Right to Information Act, we could able to take information from the government, but otherwise the government was very secretive, and in such processes the evidence may not come out. So, NHRC can demand for such records or evidences from the office. So, because it has the power of civil court, the National Human Rights Commission can demand any public authority for its records, and it also can issue summons for its witnesses of such evidences. So, we may have individual witnesses or witnesses in the nature of documents, recorded documents. So, NHRC also has power to demand such records from public offices. So, there was a lot of amendments brought to the National Human Rights Commission by passing a bill in 2006. It has changed many provisions of National Human Rights Commission. So, basically it has made arrangements regarding composition of State Human Rights Commission. It has reduced the members of State Human Rights Commission from 5 to 3. Today, at this time, we have 1 chairman and 2 members of the State Human Rights Commission. So, this is a major amendment which has gone in recent time. So, as we said, in this amendment in 2006, the number of members of State Human Rights Commission, here the members have been reduced from 5 to 3 in State Human Rights Commission, not National Human Rights Commission. It is that every state should have a State Human Rights Commission, and the members have been reduced from 5 to 3. Now we have one chairman, that is one chairman and 2 members, and also eligibility conditions have been modified in the appointment of members of State Human Rights Commission. So very important amendments which we have made by the 2006 Act. We have modified few things, and here we also, by this Amendment Act 2006, we have strengthened the investigative things of National Human Rights Commission. As we know, National Human Rights Commission or State Human Rights Commission have to investigate in the matters of violations of human rights. So the nature of investigation have been strengthened. Here the Human Rights Commission can use its own investigative body or can take the help of other investigative agencies. Here to come to any conclusion, there have to be a detailed investigation, because there might be a lot of allegations against the government or against any public authority in the matter of violation of human rights. There may not be any real things also, or there may be any political game where the other parties could allege on the government regarding the violation of human rights. So the National Human Rights Commission have to be very transparent, very balanced in its approach. So it has to investigate the details of such violations in a very very rational and very technical way. So in that case, this act has amended that. It has strengthened the investigative material available with the National Human Rights Commission or State Human Rights Commission. So it also empowered the commission for the compensation. Generally before this, the Human Rights Commission did not had the power or authority to compensate, or they did not have authority to punish. But by this act now, the NHRC can compensate the victims, or they can recommend on the compensation of the victims. Okay. So here one more amendment here is this amendment has empowered the Human Rights Commission to visit jails or detention centers without informing the state governments. What generally happens is, when a team visits the jail or detention centers, generally what happens is they will cover up most of the matters of violations of human rights. So if the NHRC or State Human Rights Commission visits any jail with prior information, the things will be changed there. Now the amendment have empowered the Human Rights Commission to visit jail or any detention center without intimating the state governments. So this is a very big change which could make a real picture clear to the Human Rights Commission. They can visit to such centers where the violation has been made, or where the allegations of violations is done. So in that places, the team of Human Rights Commission could visit. And it has also in this amendment we have seen that there is a strengthening of evidence regarding witnesses. So the witnesses can also be taken by National Human Rights Commission. So we have other amendments regarding this. We can say that the National Human Rights Commission can transfer their complaints to the concerned State Human Rights Commission. Generally, the National Human Rights Commission is burdened with many of cases. So on various subjects which are mentioned in state list or concurrent list, or the place of violation of human rights. So here the National Human Rights Commission can transfer such cases to concerned state also. So here chairpersons, enabling the chairpersons and the members of NHRC to address their resignation in writing to the president. Here the president, though the State Human Rights Commission members are appointed by the governor, they have to be removed by the president only, or their removal, their resignation letter is also submitted to the president. And here chairman and members of the SHSC to the governor of the state concerned. When the matters now after this amendment, we could see that the resignation letter could be given to the governor if the State Human Rights Commission chairman or members want to resign from their post. Now the governor is the authority where such resignation letter could be submitted. So we also know that in National Human Rights Commission there are ex officio members also, that is members of National Commission for SC, ST, and we also have members from National Commission for Women. Such ex officio persons are made, they are deemed to be members of the National Human Rights Commission, because before this act they were ex officio members, they are not permanent members of the commission, but after this amendment they are deemed to be the members of the National Human Rights Commission. So this is regarding international agreements, conventions, covenants which the National Human Rights Commission would be not taking those recommendations for the strengthening of the agency of National Human Rights Commission and to make better environment for the living conditions. So this is again, we have amendment, we have introduced a bill in 2019 which has provided for appointment of National Human Rights Commission, where two persons are to be taken who have deep knowledge and understanding on human rights are appointed as the members of the National Human Rights Commission. Just to understand, we have National Human Rights Commissions and the State Human Rights Commissions in various states, which generally have similar functions of National Human Rights Commission, that is protection of human rights. So we will have a quick check here. We will take few questions just for the understanding of the subject. National Human Rights Commission is we have to know that it is not a constitutional body. The National Human Rights Commission is a statutory body, and it is also a multilateral institutions, multi-member body. So the answer would be both A and C. Here we can eliminate the option here, it is not a constitutional body. So who is the current chairman of the National Human Rights Commission? At present we have H.L. Dattu, who is the current chairman of the National Human Rights Commission. Generally, National Human Rights Commission, the chairman will be a retired Chief Justice of India, because that is the highest body, that is the highest legal body, being Chief Justice of India, that is Chief Justice of Supreme Court. So retired Chief Justice of India would be acting as a chairman of the National Human Rights Commission. And if we take the State's Human Rights Commission, the High Court's Chief Justice can be the chairman of the State Human Rights Commission. So who can be appointed as the chairman of the National Human Rights Commission? Any sitting judge of the Supreme Court? No, not judge of the Supreme Court. Any retired Chief Justice of the Supreme Court, CJI, Chief Justice of India. Chief Justice of India is the retired Chief Justice of Supreme Court, Chief Justice. So only Chief Justice of Supreme Court, that is retired Chief Justice of Supreme Court, could be appointed as the chairman of the Human Rights Commission. So this is the correct answer. Any person appointed by the President? No. Retired Chief Justice of any High Court. Retired Chief Justice of High Court would be chairman of State Human Rights Commission. So here when we are talking about National Human Rights Commission, it has to be any retired Chief Justice of the Supreme Court. So what is the tenure of the chairman of National Human Rights Commission? As we know, the tenure is 5 years. The tenure is 5 years or up to 70 years of the age. And one more thing we need to remember is, once the chairman or members completes their term, they are not eligible for further appointment. So here the answer is 5 years or until the 70 years of the age. Who of the following is not included in the committee constituted for the appointment of the chairman of the National Human Rights Commission? As we know, we have an appointment committee here, and in this The president is not included. President is not included in the appointment committee. We have prime minister who heads such committee. We have home minister. We have Lok Sabha speaker. We have deputy speaker of the Rajya Sabha, and we also have two leaders, that is opposition leaders from both Lok Sabha and the Rajya Sabha. President is the appointing authority. National Human Rights Commission's chairman and members are appointed by the president on the recommendations made by the panel headed by the prime minister. So, in this question, president is not part of the appointing committee constituted for the appointment of such dignitaries. Where is the headquarters of the National Human Rights Commission? As we know, National Human Rights Commission is now headquartered in Delhi. We also have the provisions that National Human Rights Commission can also set up their branches anywhere across the country. But at present, Delhi is the base where we have National Human Rights Commission. Which of the following is not the functions of National Human Rights Commission? Not the functions. We have to be very careful when answering such questions. Not the function of the National Human Rights Commission. To interfere in the proceedings related to human rights violation case pending in the court. This is true because we've done this when we are talking about the functions of Human Rights Commission. This is correct answer. Actually, this is a function of the National Human Rights Commission. Protecting the human rights of the prisoners. This is also true. This is also function. To provide economic compensation to any human rights violation. See, the National Human Rights Commission will directly not compensate. It will recommend on the compensation of such violations of human rights. So, answer is C. This is not the function. This is not the direct function of the commission. It has a recommendatory nature, and in general, the recommendations of the National Human Rights Commission are not ignored by the governments, be it central government or the state government. The recommendations are, they will in general accept such recommendations because it's a very specialized body headed by Chief Justice of India. So, the recommendations are in general accepted by the government. And obviously, we have seen that promoting research in the field of human rights, yes, it will study into the various matters at international agreements, international conventions, and it will try to add such experiences in the recommendations made by NHRC to the government. To provide economic compensation is not a direct function. So, here in this question, answer would be C. When did the NHRC of India constituted? In 1993 is the year where NHRC is constituted, both at state and union level. Here, when we say Central National Human Rights Commission, it's at national level. So, NHRC consists of a chairman. It's a 5-member body in total, 1 chairman and 4 members. So, we have chairman and 4 members. Chairman and 4 members. In State Human Rights Commission, we have chairman and 2 members. Which of the following can be the chairman of NHRC? So, we have already done this. Which of the following can be the chairman? Chairman is any retired Chief Justice of Supreme Court. Anyone who is appointed by the President, any sitting judge of the Supreme Court. So, here the answer would be Chief Justice of the Supreme Court could be the chairman of National Human Rights Commission. National Commission for Women. As we know, National Commission for Women is also a statutory body, that is, it is created by Act of the Parliament. It is created by the Parliament. So, it's not a constitutional body, it's a statutory body. And National Commission for Women, in this class we would be discussing the need for this commission, the composition of the commission, what are the members, who are the members of this commission, and what are the various acts which has been implemented after the recommendations, or which has been amended or modified with the recommendations of this commission. So, as we know, we have a very significant place for women in our country, and we also faced, in this country, we also seen lot of atrocities, lot of violence against women. So, to curb such activities, to safeguard the rights of the women, we have created this National Commission of Women. So this National Commission for Women has been created in year 1992. Before that, we did had the body which could look into the matters of atrocities or violence against the women. So in 1992, the National Commission for Women has been created by an act of the Parliament. So it was set up as a statutory body. As we know, when we call it a statutory body, it is created by the act of the parliament. So ఈ జాతీయ మహిళా కమిషన్ అనేది ఒక పార్లమెంట్ యొక్క యాక్ట్ ద్వారా ఇది ఎస్టాబ్లిష్ చేయబడింది. ఇది ఒక రాజ్యాంగంలో ఎక్కడ మెన్షన్ చేసి లేదు. సో ఇట్స్ నాట్ అ కాన్స్టిట్యూషనల్ బాడీ, ఇట్స్ అ స్టాట్యుటరీ బాడీ. అండ్ వీ హ్యావ్ అ నేషనల్ కమిషన్ ఫర్ ఉమెన్స్ యాక్ట్. This was the act which was passed in 1990, and in 1992 we could establish or create a statutory body in the name of National Commission for Women. So the important role, what is the important role or need for creating such a commission? So the important thing is, as we know, half of the population is women in any country, and obviously there is a lot of hardship, there is a lot of violence which is faced by the women, and in many instances those violence against women are not registered. So you take any example, right from sati system, we followed in past times, sati system. We have domestic violence faced by women, dowry, regarding rape and abuse or harassment in workplaces. So there are many such instances where women face many problems in their lives, and many such instances are not registered or they are not recorded. So there are many things which stop women to come forward and register their complaints because of the nature of the society. Generally, we have a patriarchal kind of society where women are generally not given the economic or whatever powers, freedom they generally should have. So its mission, the mission or the role of National Commission for Women is to achieve equality among the society. So women should be given equal importance. As we know, we have many fundamental rights in part 3 of our constitution which provides equality. For example, when we say equality, article 14 talks about equality, but we practically see many instances where women are treated not along or at par with the male. So it started, it is in deep roots of our society, it is rooted in our culture where women are not treated equally, and this has been continued for long years. But the time has changed, women has become more aware. But still, in many parts of the country, we generally witness many such instances against women, which is really a shame to the society. So to protect and safeguard whatever the constitutional rights provided for the women, we need to have a strong body, strong agency which could take up the matter and which could advise the government on various policy matters which affects the women's safety and obviously their welfare and development. So the important mission of this National Commission for Women, is to achieve equality and equal participation. As we say, equal participation. When could we achieve real equality? When the government or when the society provides opportunity to the women. It might be political opportunity, social opportunity, or economic freedom. So all this has to be provided to the women. It's not only the job or duty of the government, but right from the family level, family should give opportunity to make a woman to feel free, to come out and work, to become financially independent, to choose their partners, to choose their education. So all these things should be given to the women in order to achieve equality and participation. So for this mission, the National Commission for Women would would strive relentlessly to make sure that the women are given equal position. So her rights and entitlements in the formulation of policies should be safeguarded. So this is obviously this body also established. The second important mission of this body is to safeguard, to ensure that whatever the rights are mentioned in the constitution for the welfare and development of the women, for the safety of the women, those rights are safeguarded. As we know, there are many fundamental rights, right from Article 14, freedom of equality. We have a freedom of religion, article from 25 to 28. So all these rights have to be protected by this body, by such bodies, where the women could feel that there is a agency, there is a body which will generally listens to their grievances. So even the National Commission for Women is also a quasi-judicial body. It has the power of a civil court. So it will generally take cases suo motu also, or the woman who is a victim can also directly go and file petition in front of this commission. So the important thing is to review the constitutional and legal safeguards for women. So time to time the things will be changing. Every time there have to be a new act according to the changing situation. So National Commission for Women is a continuous, it will review the things continuously and recommend or advise the government on various law which need to be amended or new law which need to be adopted regarding the women, regarding the changing conditions and situations. So the important thing is here to review the constitutional and legal safeguards. For example, we could able to abolish sati, we could able to abolish dowry system, we have prohibited human trafficking. So many law which has been amended or made more stringent, made more strict, and punishment have also made more stringent, because there is a continuous review of the constitutional provisions which are targeted towards protecting the rights of the women. So one of the important function is to review the constitutional and legal safeguards for women. So this is the first commission was established in year 1992, and Jayanti Patnaik was the first chairperson of the National Commission for Women. So Jayanti Patnaik was the first chairperson of the National Commission for Women. So it was created in year 1992. So what is the composition of the National Commission for Women? We have a chairperson, member secretary, and five members. So in total we have 7 members, chairperson, member secretary, and 5 members. And generally chairperson would be selected. All these 7 members are selected by or are nominated by the central government, and there is no qualification mentioned for the term or for the eligibility of these 7 members. But obviously any person want to be a part of commission should have knowledge about the problems facing by the women. So generally any entrepreneur or a union leader or administrator, professor, any person who has a vast experience in running NGOs which works for the upliftment for the women. So the union government would select such members who have interest, who have passion towards service of the women. So in terms of composition, we have 7 members, 1 chairperson, 1 member secretary, and 5 members for the commission. So these are the important functions: inquiry and investigation, action, research, legal intervention. These are the general things, but let's go get into the detail. As we say, inquiry and investigation. So National Commission for Women would inquire on various matters which are which are generally used, generally faced by the women, like we have atrocities against women, where the women generally deprived their rights, both fundamental rights and human rights as well. So into such matters, this commission will look into it, will investigate and inquire. As we know that the commission has a power of civil code. So the power of civil code, by having this power, the commission could issue summons or call any person to give an evidence, to call for its documentations. So it enjoys the power of civil court. So it inquires into matters related to the atrocities faced by the women. We have seen many cases, like for example Nirbhaya case, which had happened in Delhi. After that case, there were many law which has become more stringent, which has made such crime like rape, murder, molestation, such crime as more punishable. So the commission would suggest the government or advises the government on various matters which could safeguard the rights of the women. It also investigates and examines the matter related to the society. So we have a feminine society. Whatever the matters faced by the women at workplace, in schools, colleges, in any places, in farms, fields, so all those things will be taken up by the commission, and it would recommend the government, various state governments or central governments, on various matters which could safeguard, which could protect the rights of the women in the society. So generally we have a woman should be given confidence from all the levels. First is the constitutional provisions, whatever are there which protects the women's right, should be implemented, and the government should also become more aware towards the welfare of the women. It has to provide, it has to give opportunity to the women to lift them from the poverty, from unemployment, and give them equal status with the women, right, by providing reservations maybe, or by giving special incentives. So for socio-economic development of women, the National Commission for Women would suggest the government on various measures to be taken by the society or by the government. So in all spheres, be it political sphere, business, society, the commission would suggest the government on various policy matters when the government frames any policy. So these recommendations are kept in mind, which has an implication towards the upliftment of the society. So we have alternate dispute redressal mechanism also, where National Commission for Women would run this. Parivarik Mahila Lok Adalat. Adalat is an ADR, it's an alternate dispute redressal mechanism, just like we have Nyaya Panchayats. So we know many cases, if we go to court, it would take a lot of time there. There is a waste of money also. So for immediate disposal of such cases, for example civil cases or criminal cases, this Mahila Lok Adalat will redress those grievances. So Mahila Lok Adalat is also formed by the National Commission for Women. So for the speedy disposal of cases, this Mahila Lok Adalat is functioning, and many cases are been disposed by the Lok Adalat. So it also investigates on various matters which strengthens the rights of the women. It also strengthens the various provisions which has to be implemented by the government, by the court, or it has to be taken into view that various administrative measures or governance measures which are directed towards the upliftment of the women should be implemented. So, the main thing is all those recommendations annually should be submitted to the central government, and there will be a discussion in the House of Parliament on such reports also. Generally, whatever the advices or recommendations of the National Commission for Women will be considered by the government where it is in the matters of formulations of the policy, and in strengthening and safeguarding the whatever rights the women should have. So, the reports are tabled. So, these reports are generally in the nature of recommendations, but the government would effectively implement such reports for the development of women. So, many legislations what we have today, for example, we have indecent representation of women, might be in media, in print media or electronic media. If there is any representation of the women which is not decent, that is which is not against the morals, so such acts would be punishable. So, we have an indecent representation, we have harassment, we have domestic violence, we have prohibition of dowry system, prohibition of sati system. So, all those legislations, be it preventive or curative, such legislations should be brought by the government, and the National Commission for Women would review all those legislative measures, making it more better to suit the conditions of the society. So, it's a continuous work by the National Commission for Women to have a continuous review of all those legislations which are in action or which needs to be brought in. So, both preventive and curative measures should be taken by the government, and those measures are recommended by the Commission. So, we have other cases of violation against the women's rights, or there is a harassment in public places, there might be property issues, or there might be issues related to divorce, dowry. So, all those things has to be taken up by the Women Commission, because most of the cases, especially in rural areas, the section of the people who are not educated or illiterate section of the society, they are generally the people who face more of such problems. So, the National Commission for Women have to make sure that such rights which are already there in the law should be strictly implemented. So, the Commission would also take suo motu cases, not necessarily the victim should go to the Commission by having a petition, but the cases, very popular cases as we can generally say, those cases are suo motu, taken by the Commission, and order an inquiry in such matters, which has a very significant role to play in future, that such incidents are not repeated. So, there are many things like it looks into complaints, matters relating to the deprivation of women's rights, non-implementation. We as know that there are many law, but they are not implemented. So, non-implementation of such law should also be taken by the Commission, and it should put pressure on the government to make it more stringent, and it should bring awareness among the women by circulating news or having a magazine of its own. So, all those things should be taken up by the Commission, so that they could bring awareness among the women. So, we have a National Commission for Women. It's a topic where generally it's important when we substantiate any answer. We may not expect any question from this, but when you write essay, you need to know, you need to substantiate the National Commission for Women, what are the main legislations which are implemented, which could safeguard the rights of the women, which could improve the livelihood of the women. So, thanks for watching this class.